Good afternoon, everyone. Welcome to Ask the Lawyer. My name is Heather Rafter, and I'm with RafterMarsh, a transatlantic law firm. And we're very excited to be here today. We're having a little bit of technical difficulty with the slides, but lawyers can talk all the time without any kind of visuals behind us. So no worries about that. With me, I've got my colleague, Philipp Lengeling of RafterMarsh, and Francine Godrich, who is with Focusrite, and we've fiercely negotiated many deals against Focusrite. So she's a frenemy, right? And she's an attorney as well. So I'll let everyone introduce themselves, and then I'll say a few words about me.
Great, thank you. I'm Francine, as Heather said. I am the General Counsel at Focusrite, and I think most of you will know Focusrite. It's quite acquisitive. It's always looking out for the next idea. We get a lot of people approaching us, which is really why I'm here today to talk to you about how you might think about formulating your ideas with a view to exiting and maybe being bought out by a company like Focusrite.
And I'm Philipp Lengeling. I split my time between New York and Hamburg, Germany. And beside being a lawyer, I'm also a musician, a passionate musician, who's not made it as a musician, but is therefore happily practicing law.
If you watch our video that we prepared for ADC, your beats are behind it.
Yeah, there was a reason I did not put my credits there. That is true. And in addition, I take care of a lot of our European-based clients who do business in the U.S. And beside my work as a lawyer, I'm an adjunct professor at Fordham Law School. That is a law school in New York City where I teach foreign lawyers how to practice law in the U.S. So focus on my practice is very much translating, not only languages from time to time, but also legal concepts, mentality, and culture in a way, because most of our companies and businesses are being offered across the globe, and it helps to understand the slight differences between culture and law.
I began my career, I was there for 14 years. How many of you are old enough to know DigiDesign? Okay, they became Avid Audio. Yes, Stefan does. So I was there for 14 years. I was the general counsel, and during that time we acquired M Audio, Sibelius, U.S.A, which was the virtual instrument group, and I said M Audio, a bunch of companies. I love Pro Audio. That just really, I was always passionate about IP, but really working at DigiDesign during its amazing years. I worked closely with Ed Gray, who many of you know. We did a third-party developer program. Anyway, if any of you know Ed, we're just gonna do a quick shout out to him because he's retiring. And anyway, I digress on that one. But I love being at DigiDesign. After 14 years, I decided to start a law firm, and I was lucky enough to have Universal Audio and Euphonics reach out and start working for them. And now we have how many clients in this space, Philip?
I think we counted the other day, and we represent about 36 audio clients. So they're
a lot of small. We really like representing startups to medium size, and then help them on exit strategies. So come see us. We've got a table upstairs in the exhibition hall. And for those of you here, we're really impressed you're here because the competing programs actually involve past and present clients. Right now, 4AA, which was acquired by Digico, is doing a panel, and Plug-in Alliance and Brainwork, long-term clients of ours, are now part of NI, Native Instruments, and they're on a panel. So those of you who chose us over them, we're really appreciative, but those are great panels too. What else? Anything else? Oh, we're passionate about the audio industry. Francine and I just want to say we really care about supporting women and diversity, and we've been proud sponsors on and off for many years of that. And I also am involved in other organizations if anyone wants to talk about that. And we want to thank ADC. We've been here from the start, I think.
Very early days, yeah.
Okay, so what we're gonna do is, I don't know if the slides are up there or not, but we will make them available afterwards. We're gonna go through a really rapid checklist of issues we can talk about, and we can spill over into the lunch hour. So, and then ask questions. We really welcome questions. So the first thing is, Francine, you wanna talk a little bit about, someone has a great idea. What should they do about forming a corporation or not?
Yeah, so the first thing to do is really protect yourself, and that means setting yourself up as a limited company. Now, one of the questions we often get asked is, well, where should I incorporate? Business is global these days. Many countries have all sorts of incorporation processes. I'd say go with what you know. Look, Nigeria might be cheap to incorporate, but it's not that attractive when you're trying to sell me your company because I don't want to go to Nigeria and buy it. So have a think about the jurisdictions you know, the ease of the laws of working there, and what the country's reputation for doing business is. So UK is obviously favourable to me, but I do appreciate some people might to incorporate in the US and parts of Europe as well.
And you can have a parent company and incorporate in other countries, lots of options. So we just want to keep that in mind. And the main reason you want to think about incorporating versus being a sole proprietorship is, I forgot to mention, I'm dual licensed here in England and Wales and California. But in both locations, being a corporate entity can provide certain protections. Correct, Francine?
That's right, yes.
Okay, there we go. So, and also think about, I hate to say talk to a lawyer because that sounds, anyway, it's helpful if you're thinking about someday having an exit strategy, figuring out what's the right entity for giving out equity and things like that.
I'd echo that, because one of the things you look for when you're thinking of buying somebody else's business is how clean and easy it is to buy. And the last thing you want is sort of someone coming to you and saying, well, look, I set it up and they've got this massive pile of papers or, probably files on computers now.
Sorry, could you speak into the microphone, please?
Yeah, sure. We'll bring them a bit closer. We can share it. It's easier if you've had a lawyer who's advised you from the beginning and they've got your company in order, because it's so much easier and quicker to buy it that way.
Okay, so can everyone hear me? No one's ever accused me of being soft-spoken. So, all right, protecting your IP is another topic we're happy to talk about. There's 5 kinds of protection. We'll do this round robin really quick. Copyrights.
Copyrights. Copyright is, all creative human works fixed in a tangible, human. That's
AI, we could talk about that if people have questions, yeah?
Fixed in a tangible medium whole copyright, meaning you got to be a little bit creative, you got to be human, and you need to sort of fix it and put it in a tangible medium, meaning you have to record it or write it down. Once it's fixed, then you have something to prove that you actually enjoy the copyright. That's a very important one for many of you who may be developers at the Audio Developer Conference. So, when you write your own code, you, by default, at first, are the copyright holder and owner. And
Registration in the U.S. has certain advantages. It differs in other countries. We're happy to answer questions about that. Mm-hmm. Who wants to do trademarks? Focusrite. Can people use the Focusrite name, Francine?
Absolutely not. Absolutely not. We've protected it across the world actually now, because we have found that there's a lot of value in the name that you give your business or your product, and people will want to copy a good thing. So we have protected Focusrite across the world, and we do enforce it. And that's something to think about. I mean, it's a relatively small cost to protect a trademark. It's about £500, £700 to do it. But the advantage that can bring you if someone's trying to pull a fast one over you and steal your product name, the benefits really outweigh that small cost.
Scarlet's not a good name for a company?
It's definitely not a good name
Magenta,
for a company.
okay?
Yeah, Magenta's okay.
All right, we'll answer questions like that. All right, patents. How many of you want to hear a little bit about patents? Okay, well, we at our firm have someone who specializes in patents and works part-time at a patent firm. So he would give a more in-depth answer. We're sorry Zach's not here. But patents are a good way. It's not inexpensive for protecting your products, and something that is time sensitive. So you've got to really think about, if you have an idea, keeping it not disclosed or carefully disclosed under NDA so you don't miss the timeline to file a patent. That's the topic. And there's something called provisionals, which is a more inexpensive way to protect your idea while you think about whether you're going to spend. Sorry, it's somewhere between $10,000 and $20,000 to file a patent in the U.S. It's an expensive process.
But there are other ways to protect your IP. One thing is a very practical, but also has rules around it, is saving the domain name. If you have a company that you're starting or a product or so on, it may make sense to look into, making sure that you have that domain name acquired. So do so as early as possible, even if you're just starting out. And the domain name, depending on what the domain name is, maybe also be protected by trademark law. So there's an overlap on how you could potentially even stop someone else using a domain name that could identify or could be misleading of where the brand is coming from or who the website is running.
And I did not really articulate, I should probably say, since it's being recorded, patents are for the protection of products, processes, and designs, different than copyright, trademarks, and trade secrets. Interestingly, something cannot be both a trade secret and patented because when you file a patent, you actually reveal your processes and the invention. Who wants to talk about trade secrets? That's the last form of IP protection.
Yeah, very U.S. Also the term, but trade secrets are generally information that derive independent economic value, actual or potential, from not being generally known to and not being readily ascertainable through proper means. And you must take reasonable measures to keep such information secret. So in essence, it's whatever makes your company and your ideas of value, and that's not known to the public. So how to protect it? We've mentioned a few ways, but the most important one is probably also making sure that the people you're sharing your information with sign something called an NDA, it's a non-disclosure agreement, and that will, at least from a contractual perspective and by law, will protect whatever is meaningful and confidential and important to you and your company.
So NDAs are great. Read them though. People think you can just sign them, they're all the same. They are not all the same.
And sometimes, you have mutual NDAs. That means both, you're sort of going on the same page into a conversation. Each party can share information, and it may, depending what the definition of confidential information is in the agreement, both sides would be protected. But there are also, one-sided non-disclosure agreements where only one party shares confidential information with the other. And sometimes it's not really clear when you just look at the title. So make sure your side is protected. And sometimes they also include penalties. So yeah, make sure to read before you sign.
Francine, from your perspective, if you're thinking about buying a company, are you more impressed that they've kept their special sauce confidential through trade secret protection, or do patents have value? What do you think?
I think both. Everything has a value, no matter what protection you give it. What is important to us as a company is that it is properly protected when we're looking at acquiring somebody.
All right, so the one thing you can't see because the slide is not up, so we will get you the slides, just come to us. We have a non-exhaustive list of legal considerations for audio developers. We are going to do this so quickly.
And why are we doing it quickly? Because we want to give you a chance to answer questions that could be relevant or interesting to you. But we also at least want you to be able to issue spot. We don't need to understand everything after 20 minutes, now actually 10 minutes of a legal panel. But the most important thing for any developer, wherever you are, to at least be able to spot the right issue and then deal, appropriately or responsibly with it, so you don't fall into any traps.
All right, we're going to share this piece of paper. We're going to read through it. You want to start with the first one? You already talked about that a little bit.
Yeah, but let's really skip through them quickly so we have some.
Okay, we have 3 minutes. Someone start timing. Let's go.
Okay, so corporate formation, which we talked about. Think about where to incorporate your company and what sort of company you're going to incorporate.
Okay, it has liability issues, tax issues, insurance issues. Think about all that in the basket of corporate formation and starting off your business. Employee invention and assignment agreements. We sometimes call them proprietary invention and assignment agreements. You might have heard the phrase PIAs. That's what that stands for. That is the key thing. You have people, either independent contractors, I'm taking both bullets, sorry, or employees. Make sure you have agreements that assign to your company, or you, if you're a sole proprietorship, the IP rights. This is the number one rule I can tell you all. You must own the IP if you are thinking about a stress-free business and also someday selling it. Anything else?
And we have so many people coming to us that they're partnering and teaming up with other folks, who help on something. And it's a really creative and great process. And usually you have, sometimes it's friends working together. And but even in situations such as this one, it's really good and useful from the get-go to make sure that at the end of the day that the expectations are met. We can still sometimes formalize and make things a bit, more, put them into the proper legal shape, but it really makes sense that all parties involved in the creation of a product are on the same page.
And the forms are simple, and there should be some consideration for it. Of course, you should pay for this. It makes it more enforceable, at least in the countries that I know about. So happy to help on that. Okay, but we're keeping within our 3 minutes. NDAs, anything else to add about non-disclosure agreements?
I think as somebody who's starting out in a business expect to receive a one-way NDA, there's no way Focusrite would enter into a mutual NDA with someone coming to sell them one of their ideas.
Hire us to negotiate this, okay? Yes?
Sorry, I didn't get that. Could you expand on that?
So for a non-disclosure agreement, if you are coming to a company wanting to sell out your idea, expect to receive a one-way NDA rather than a mutual, because Focusrite, for example, is not going to share its information with you. It's the other way around.
Oh, but you'll protect his ideas. You'll say, we'll agree to protect yours, but you're not going to be providing any, is that what you're saying?
Yeah.
Oh, okay.
You would do a mutual, but not a one-way.
No, I do one-way rather than mutual.
Now, we actually would have a different perspective. We would say, well, even if the company we're representing doesn't plan to share ideas, we might as well make it mutual. They don't have to say anything, but at least we can argue we shared ideas.
And then they have certain liabilities towards you as well.
So, see, everyone has a different opinion on these, and both are very valid. Okay. Software licensing agreements, there's no way we can cover these in 2 seconds. Use them.
Yeah, and there are various formats of how you could license your software, right? There are open source licenses, but there are also, closed licenses that are very specific on what you can do with whatever you're licensing, or vice versa. So that's a lot we can talk about if you have more questions about that.
And there's inbound and outbound. Read the ones when you're licensing in, even if it's your drivers, everything. Just make sure you understand the terms of the agreements that when you do inbound licensing, not just outbound.
Yeah, and that goes back to copyright and so on, right? So anything, granting licenses and trademarks.
Sophie, nice to see you here. Our slides don't work. That's why those gorgeous ADC logos are not up.
I know, but I think Aidan's just putting them all on
Okay,
Discord. so
great. All right,
they're available
how
there.
many of you are hardware manufacturers?
Nice.
Okay, that's something else we can talk about, those agreements and all the compliancy requirements.
And then we have for software also dealer and distribution agreements, right? If you're not distributing directly, you could partner up with other companies to distribute your content, like Plugin Boutique, or, we represented Plugin Alliance for a long time.
And if you are distributing directly, make sure you think about your terms and conditions on your website, of course, end user license agreements for software, and privacy policy. Philip's very modest, but he's certified as a privacy specialist.
Yes.
And we have someone else on our team as well, Jessica. Okay.
Yeah, leases, if you have an office space, make sure that you read the fine print. Anything, yeah, go ahead. This is also a good Francine one.
Regulatory licenses. Oh, there are so many. You want to talk about how much fun compliance is with hardware, or move on?
I think suffice to say, take advice on what compliance licenses you need.
CEUL, ROAS, yeah. Okay. Encryption is another area. If you have encryption in your software, there's regulatory requirements by government on that. Philip, your favorite, territorial considerations.
Yes, I mentioned that earlier. I think, copyright, also the concepts, the idea, the background, each country has slightly different approaches historically. So it's important to make sure that when you're licensed, for example, for a U.S. company, if you deal with German authors, they enjoy special protections, having moral rights, etc. You'll read a moral rights waiver in some agreements, but maybe they're not even enforceable. You could still, deal with that. But that's something to consider. And sometimes you would also find, or oftentimes you would find a choice of law provision in your agreement that at least pulls you towards one particular jurisdiction.
We already talked a little bit about privacy and data protection compliance. So since Francine or Philip, what about when people, you guys just think, oh, I just collect emails, no issue. I don't do the credit card processing. Do they have to still worry about these issues?
Always. Any personal data, by definition, that's any data that's related, that can reasonably connect it to an individual, is personal data. So there are regulations, laws across the globe, and there are more and more laws coming up. The GDPR is the most famous one, but we have in California the CCPA, the CPRA. and more states within the U.S. also come up with their own set of privacy rules. So again, it's important. Most important here is transparency and understanding to what extent you may lawfully process data. And it's not always no. It's actually, yeah, you can do almost everything if it makes sense and if it's fair and if it's transparent, but you just got to do it the right way. And that's very important from the get-go.
Anything else on that topic of privacy and data compliance? It's a very complicated topic, including transferring your IP,
And
cross-border. There's a lot of issues.
And
right?
one more point about that, especially as small companies, some may neglect it and say,
Yeah.
oh, what authority is going to, approach me after this? Am I going to stay, under the radar? I sometimes, the most important thing in such contexts is not to piss anyone off, right? You may have a customer who's unsatisfied, or you may have a competitor who feels like you stepped on their toes. There's only, if you're pissing off the wrong person and you then get raised to some authority and you're then flagged, then it gets very annoying. So make sure that at least the tip of the iceberg is polished, and then the rest of the iceberg, it's a long process to really be fully compliant, but that's something attorneys can help you with, and being aware of it and dealing with it responsibly it's not hocus pocus.
And there's a lot of ways, we know smaller companies go online and use these wonderful software programs, these programs to spit out privacy policies and terms of use. The most important thing, if you go that route, of course, we think going to attorneys is better, is make sure you do what you say you do in the privacy policy.
Yeah.
I learned that from you, Philip.
Oh.
Okay. IP protection, we already covered that, didn't we?
We did, but I think it's worth emphasising it's a big deal, especially if you've got an ITO exit, because anyone buying you is going to want to know that the IP belongs to you, is enforceable, and has value.
So something, this point is legal compliance checklists and product lifecycle. What this is, and we don't have time to really cover it, is at what point in developing a product should you think about IP protection? One thing you might not know, at least under U.S. law, you can file intent to use applications for your trademark, so you can secure a name before you actually ship a product.
And that's also possible in the EU. There it's actually less strict on providing evidence and so on, but obviously you would only have an enforceable trademark if you actually are using that particular trademark term in commerce.
And the value in the U.S. of an intent to use filing is you can make sure the name is available and you get rights before you ship a product. But then of course, you have to prove that you actually are using it in commerce. Okay. And then the product life cycle is, just think about at what point in the development of a product do you want to do the next point on the legal checklist, right?
Absolutely
Like-
right.
Okay.
Marketing policies and procedures, localization, endorsements, and other practices, massive area. But if you are going to get someone else to either market or sell your product, please have an agreement. It's very hard when they've run off with all your kit.
Can I say my products are better than Focusrite's?
Yeah, you can say it. Yeah, sure. We have freedom of speech. You might get sued.
But again, yeah.
Right. So you got to be careful about comparative advertising. And if you do say that and it's not true, Francine's going after you.
And again, certain countries have different laws about this. So here, you may even get sued or receive a cease and desist letter, even if you haven't done anything wrong. But you will still deal with it. So a little bit of human sense makes sense too when you're when you're releasing or advertising.
If you're going to do a product feature comparison for your product and want to compare it,
It needs to be factually correct.
make sure it's factually correct. Describe the methodology. And most things that we're talking about, being accurate is the most important thing. So.
I think the one thing I'd say there, having done quite a bit of comparative advertising, is that what you think is factually correct will definitely not suffice if push ever came to shove on this. So it is really important you take legal advice if you want to compare your products with other people's.
So kind of stay away from that if you can and
I
rely
would.
on the strength of your own product unless you consult with counsel. I like that answer. Okay. Oh boy. We just did a panel on this at AES and we'll get you the link. AI best practices and compliance issues, where you gather your data, the training sets, what's protectable, who owns what rights. It is an enormous topic. We'll take a question on it, but we will also get you the link for the panel we did at AES, the Audio Engineering Society show a month ago.
Yes, and that is relevant for both developers who implement AI technologies, who use AI to write their code, but also if you create a tool that helps the end user, create their own content using AI that you provide to them. And then so yeah, it's both in creation, usage, and then.
How many of
whatever
you are
outcome.
you currently using AI in product development? Okay, yeah. So know where you're training your data. Like that's the rule number one, right? Know where it's coming from. And then there's all these generative AI issues. We'll get you the link for the panel on that and take questions after. Okay, online contracts. We already talked about that, did we not?
We did.
Yeah, online
Terms of
and
use, privacy
services.
policy. He loves cookie policies. He's nuts about those.
Yeah, I may have spoken about cookies per se, but the policies are okay too.
All right, anyone want to talk about MAP and UPP, minimum advertised price, and universal price policy? This is when you're selling products, how to protect pricing. It's a big topic. I'm glad no one is raising their hand.
And
Thank you.
but we should definitely, that is one of the territorial big things. Mapping, agreeing on a minimum advertised price is legitimate in the US. It's not legitimate under EU antitrust and competition laws. So here again, sometimes you need to translate concepts to your transatlantic contractual partners to just ensure, look, we would love to agree to a minimum price, but our laws don't allow this because the consumers are protected and want to keep competition alive.
What is the minimum advertising price?
That's the, MAP is a policy that you use to try to control is not even the right word, try to protect what is the price that is being set as your MSRP, essentially.
Yeah, it could mean I'm giving my product to a third party and I'm telling that third party, you cannot sell this below 10 euros per software license. That's something you can do in the US, at least if you follow certain compliance measures. It's not possible in Europe, even though you can, of course, there are ways to at least be in sync about the manufactured suggested retail price, but it simply cannot be binding.
Yeah, and happy to give you more information after on that. How many of you are doing software emulations of hardware? Right, that is a favorite topic of ours, and it's a big topic, so come see us afterwards. But we can tell you some of the rules around that, but just be careful, right? If you're emulating any Focusrite products, don't get too close to them. Be very careful to make it clear it is not in any way endorsed or affiliated with unless you have a license, go carefully, tread carefully, use disclaimers, and a huge topic, right?
Yep.
All right, Francine, you want to talk on the last bullet, and then we have to take questions. This is way more than 3 minutes.
Yeah, due diligence and exit strategy. So this really is about housekeeping. Have your house in order, have all your agreements documented, know what's going on within your company, and expect to be asked a lot of questions if you have an exit strategy coming up.
Or fundraising, even.
Or even fundraising. Lawyers like nothing better than pieces of paper. So if you can write everything down, that would be much appreciated. The other thing I'd say is speak to a lawyer early on in your exit process. So get an idea of how you should be framing your company and who might be an appropriate buyer for you, because what you don't want to do is waste your time sort of courting lots of buyers when actually you could go to one person and get the same result.
Okay. Yeah, and the last thing that I would mention that wasn't on our list is one reason for speaking to council too is we try to be very helpful in figuring out the best revenue strategy. One of the first rules I learned is money matters the most to all of you in agreements, and making sure you get paid and you cut the best deal for you. So there's all sorts of ways we can structure revenue when you're licensing. It can involve upfront fees. It can involve flat fees, percentage-based fees. There's just so many ways to slice and dice it.
Something up front, yeah.
Yeah. Non-refundable expenses, advance against royalties. Anyway, it's a huge topic, licensing, but there are very creative ways to protect our clients, and we love talking about that.
Yes. Okay. So now we have, we would do about 6 more minutes if you're happy to join us here, because we already went a little bit longer. But now we're ready for questions, I'd say, right? Let's see how many questions we can answer within 6 minutes. But I do see some hands.
And then if there are any online, and we're happy to go after if that's okay with ADC.
I have, I have a question about interaction with users. So we have users that make suggestions. They're either suggestions that we've contemplated before to incorporate into our tech, or suggestions we haven't contemplated, but they're genuinely good ideas. How do we communicate with the users in the way such that they don't have future expectations?
That is such a great question. Do you want to mention what Focusrite does? Or do you want us to take it?
Without giving away any trade secrets. I think that's a really good question, and it's a really difficult area. Usually, in these circumstances, particularly where you've already got your idea, is less is more, and I think the answer is, yeah, thanks, but it's not something we take forward. Something that is developing in the industry is a kind of a paragraph that says, if you send us your idea, good luck to you. We might take it, we might use it, we might discard it. It's debatable, I think, how enforceable that is at the moment. But I think it's worth having available and accessible to your users because it just sets the tone
Yes.
of how you'd approach dealing with them.
Thank you.
And if you need their assistance, of course, then you could try to walk that delicate line of reaching out and deciding to do a formal agreement, but you don't know what they're going to charge you. So, yeah.
Hi. I have two questions. One's very simple, I think, and the other one's maybe a little more nuanced. But the first one is about EULA's licensing, and we operate in the U.S. and the U.K., and the client is in the U.K. And if we're going to grant a license to this U.K. client, what is the governance? What is the governing jurisdiction? And yeah,
You're in the U.S.,
the company is incorporated in the U.S., but the client is.
and the licensor, the person licensing is in the U.S.?
Yes.
Flex that muscle. Stick
Okay.
with U.S. law.
Yeah,
Okay.
but it also depends whether you're a customer, the licensee is a consumer or a business.
It's a business. Yeah.
Because, okay, then if you have B2B licenses, you're very flexible in whatever you agree and what's favorable to you in your end user license agreement.
Okay.
If you have consumers, some consumer laws may supersede and they will be able to at least enforce certain rights if
good to know for
in their
something
home
else.
jurisdiction. Yeah.
I do want to say, though, when we really come to an impasse on U.S. versus U.K. law or U.S. versus EU law, sometimes we do pick the laws of England and Wales, as they call it, as the governing law, and we're comfortable with that, in part because I'm licensed here as well, but also because there's a prevailing party provision. And it used to be things were less expensive. I don't think that's necessarily true, litigation here anymore. But the fact that there's the recovery of attorney's fees to the prevailing party, there's some thought that depending on which side you're on, that might stop frivolous litigation.
That's better.
What do you think, Francine?
What about
You
it?
okay, comfortable with U.S. law, or do you prefer U.K.?
No, I would always prefer UK law. And I mean, it's a law that is recognised internationally as being good for business. So I don't know why you wouldn't use it.
Got it.
Yeah, it's just that if you're the licensor and your lawyers are in the U.S., you first go is try to U.S. law. But I don't mind England and Wales.
That's good. That's good to understand
Yeah.
that there is some
But it,
sort of flexibility.
but it really also depends. If you have a lot more money than the other side, maybe US is favorable.
no, we don't.
Because
Just the one other question, if I may. It's just related to PIA, I think it is. Kind of interested in this. Let's just say that I'm a creative technologist. And I have a creative practice, and I'm a composer, and I'm out there, and people know who I am, and I'm an artist, and I make stuff like, I don't know, someone like Imogen Heap or something like that. And I make technology, but I use it in my creative practice. Does the company that I work for own that? I don't think so.
Did you have the technology before you went to the company?
No, not necessarily.
So you developed the technology on the companies, using company equipment on company time?
No.
You did it all, I'm sorry, you did it after hours?
Okay, can I answer this?
You know what I'm trying to get at.
asking for a friend.
I check what your employment contract says. That's the first place to start, because chances are, particularly in the UK, it's going to say your life and soul belongs to your employer, and therefore anything you invent belongs to your employer.
That's a tough one.
Yeah, life is tough. Employers are out to make money. What I would say is talk to your employer about it, though, because if you've got something that's not going to compete with who you're employed by, there's little value in it. And why wouldn't they want a sort of an engaged, motivated, creative person who's happy to work on their team?
Right.
So it's a conversation to be had.
Yep. Cool. Thank you.
Thank you. And I wanted to mention on your choice of law question, that's tied up with where you go to court. There's a question of choice of law and then actually jurisdiction. So anyway, we can go into more detail about that.
Yeah.
Good question for your friend.
Yeah. Hi. Hello. So, we developers or algorithm developers, sometimes we think that we have created something that is really a breakthrough, and we have this dichotomy of whether to keep it secret or patent it. But when you patent it, you are really disclosing it. So if you're not a big company, anyone can just copy it, and you will not be able to enforce, or it's difficult. So, and we have this feeling that maybe a big company will decompile your code if it's an app, for example. So is this really a justified fear, or does it really happen? Does it really happen? Or big companies are not really interested in decompiling even algorithms that are really good, and they, for example, a source separation that perfectly extracts the voice, for example, much better than anything else. Would a big company be interested in just decompiling that and steal it, or?
So I think, first of all, there are other ways than doing a patent. One is to make sure in your license agreement that you disallow decompiling and reverse engineering, at least to the extent permitted by applicable law. And the other thing is, now that's really not a legal question so much, it's a practical question of how companies deal with it. But based on experience, oftentimes when companies are interested in something, they either develop it independently, or if they find someone who does it incredibly well, they oftentimes would, and that's what's at least how when we deal with it most often times, they reach out to the developer and ask them, look, whatever you built here is incredibly cool, and we would love to either license your software, maybe even buy it, or hire you, and you could continue this. So I think being scared too much about things getting stolen by the big evil corporations is something that is a valid thought. But generally, I would take more of the NDA approach, maybe start speaking with the companies who could be interested. Or if somebody finds you, I think it's more likely that they will reach out to you than actually, in the back room, reverse engineer and steal your magic sauce. But Francine may know exactly.
I think what I'd say is get yourself a really tight NDA. Come and talk to Heather and Philipp about it and get yourself a really lovely NDA. And before you share your product with anybody, have them sign up to your NDA for it. I'd like to think that most companies will behave honourably, and they definitely will work with you to understand your product and see how it can be capitalised. But there are some rogues out there.
Yeah, sorry. In particular, what is the best time to patent something? Because the thing is that if you patent it, you're giving the clue to other companies like, okay, this is possible, and this guy took this approach, so we can do something to avoid the patent somehow, do it some other way. So my feeling is that the best moment to patent something is right before somebody else is going to buy it, so that they are buying something. So what do you think about it?
Not necessarily, actually. If someone has a great idea, that's what we're buying. Whether they've got a patent over it or not isn't that big a deal. And I think what you'd find is to get the patent protection, it's quite expensive and it's time consuming, and that might not be the best focus for you. So having a patent doesn't necessarily make you the golden goose that anyone would want to buy. And I think really patents, they do have to be really innovative and at the cutting edge. So I think you've got time to work with other companies and get a lot bigger before you start worrying about patents.
But remember, there are time limitations on when you can file a patent, and it depends on when you disclose the idea to the world.
Yeah, but it's
Publicly.
and it very much depends on what you're trying to patent and find patent protection for. So that could make sense to speak to a patent attorney specifically. Hey, does it make sense for me to at least start off with a provisional patent, or do I want to file an actual patent, because then it may make sense to brainstorm some alternatives on how to protect it, and maybe even spend your time. I think Francine responded perfectly. Yeah. Agreed.
Thank you.
I think we're a bit over on time, but just wanted to.
Were there any questions online? Okay,
Okay.
perfect. Hey, thank you. Please come see us upstairs. Francine, hopefully will stick around for a while, or we'll meet you at lunch. And most of all, thank you to ADC. We really appreciate this opportunity.